Okay, I think we got everybody now. Good afternoon, everyone, and thank you all for joining us for today's of month of service presentation of estate planning essentials for business owners. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the a month of service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, today with Lone Star Legal Aid, we have Miss Jessie Campbell. In addition to that, included in the partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops and information and resources to the community relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We know that there are a lot of underserved communities that are out there that do not have access to a lot of information for resources and don't know where to go for particular services. So several years ago, we decided to collaborate and come together and pool a lot of our programs and initiatives, considering that we do service the same community. We do have similar missions and goals in mind, and that is to try to empower the community as much as we possibly can with information and knowledge. Um, so we've been doing these presentations together. We used to do them in person, but of course, due to COVID, we've had to adjust to the virtual platform. This platform has allowed us the opportunity to reach even more people, not only throughout the city of Houston, but also surrounding counties and across the state. It has allowed us the opportunity to evolve what we have been offering because one workshop tends to kind of evolve and kind of incorporate another and another topic and another topic, but we make our adjustments based on the feedback that we receive from community members. And this particular workshop was one of those um, topics that had come up over the last several months as it relates to estate planning for small business owners or even business owners, period. We offer the first Thursday of each month. Ms. Jessie with Lone Star Legal Aid does wills and estate planning or advanced legal planning, and why do you need it? And we talk about wills and estate planning and things like that for individuals or community members. But the questions keep coming up about, hey, my father passed, my mother passed, she had a small business, or they had this particular type of business and they had this, for however many years. What happens to it? What happens after someone passes, or what is it that they can do to help protect those assets, those business assets? What needs to be done? We don't know. So I'm curious as myself to try to figure out what do I need to do to try to protect my small business, and how do I pass it along to my family or to whom I wanted to go to, or if they have to dissolve it for whatever reason, make sure that it's done properly, and that they would still be able to maintain some of those assets that we worked for. So we want to thank you guys for joining us this afternoon. Today we have a presenter, Miss Melissa Botting. Is it Botting? Did I say correctly? Botting with the Botting Law Firm, who's here on behalf of Lone Star Legal Aid to present this information to you all today. Do know that the information that does get presented is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners or to our presenter if you guys have any specific questions as it relates to your particular situation. You do have the opportunity to ask whatever questions that is that you have related to the topic. However, we do ask that you try to keep it to be as general as you possibly can, and not to get into any specific detailed information about your own particular circumstance. As we are on a public platform, we also record this session as well as broadcast live on our social media channels. So we want to try to protect your privacy as best as we can as well. So do keep that in mind. You do have the opportunity to type your questions into the chat. There were a couple of questions that were emailed to me in advance, and I have since passed those on to Melissa, who will be addressing those. So we will be answering questions at the end. If you are joining us on our social media channels, you do have the opportunity to type your questions into the comment section, and I'll make sure that your question gets read aloud at the end as well. So if you feel more comfortable, if you're here with us on Zoom and you want to unmute yourself or raise your hand, you can do that as well. So whichever, however you're most comfortable. So without further ado, we are going to get into introductions and move right on into our presentation. Again, thank you all for joining us, and we want to welcome you back to our fall sessions of our month of service collaboration. So thank you all very much for joining us, and we hope that you get all the information that you came to receive here today. So without further ado, we're going to start with Miss Cecile, and then Jesse will have you introduce yourself, and then you can introduce Miss Melissa. So Cecile.
Thank you, Nia. Good afternoon, everybody. My name is Cecile Carlson. I am one of the coordinators in partnership with A Month of Service through the Department of Neighborhoods. We're really happy to be back into our fall sessions. We took a little hiatus last month to recharge, regroup, but we're back. And with a really interesting topic, like Nia said, this is information that's typically not readily available or that people don't discuss openly, especially when it comes also to estate planning. It can be a little bit hard to approach that topic because it's sometimes it can feel a little scary and daunting, but that's why we're here to clear the information for you guys to get information straight from the subject matter experts. So today we have Jesse and Melissa, and I'm really excited to learn everything that there is to do with estate planning for business owners. So I'll go ahead and pass it over to Jesse. And again, thank you guys for being here today.
Good afternoon, everyone. My name is Jessie Campbell. I'm a directing attorney with Lone Star Legal Aid for our pro bono office. What that means is that I get to work with wonderful volunteers, such as Attorney Botting, to help with legal services for our eligible clients. You're going to get a lot of information today. It can feel overwhelming. Just letting you know you are not alone in this. If you do qualify for services, there are people and attorneys who will be available to assist you with that. All my contact information is up here. There's also our other partners, but don't worry, don't frantically write things down. Ms. Nia will send you all of that information after the presentation on how you can apply for services. So thank you so much for attending. And with that, without much further ado, I'll pass it on to Attorney Botting. Thank you so much.
Thank you, Jesse. Let me go ahead and share my screen. I just wanted to start that thank you for having me. I appreciate the opportunity, and I do hope that this is educational for folks. Let's see, it won't let me. All right. Too far. All right. The first thing that I want to start with is to point out how important it is to have a plan and to have as complete a plan as possible. I'm real concerned with folks that I've got a will, it's after I pass. Real honestly, after you pass, it's no longer your problem. I get real concerned with people who don't have any kind of planning in place during their lifetime. We all live in a dangerous world. You can be hit by a truck pulling out of your parking lot. So your plan needs to be something that can be implemented whenever it's necessary. During the time that you might be incapacitated, like I said, hit by a truck, not able to take care of your own business, is there somebody who can turn off your automated payments for you so that your bank accounts aren't being distributed for services you don't need or want? Are you able to get the required medical treatments? If your incapacity lasts for a while, are folks going to be able to take care of things? If nothing happens for 3 years, banks will send any money, any financial institution will send whatever your account is to the state. It's achievement after 3 years of inactivity. And 3 years goes pretty quick. Your taxes aren't paid for 3 years. Your real estate can be sold at a tax sale. So these are, your business may be at a standstill and nothing can happen. So these are things that your plan can't just come into effect when you pass away. It has to be a plan that becomes actualizing whenever it's necessary. Obviously, a lot of these things would continue or take place after you pass also, but it becomes expensive for your heirs to have to go into litigation to try to take possession of your assets. And it becomes very difficult sometimes, just the timing. It may already be escheated to the state or sold at tax sale by the time they get through with that litigation. I personally have some real estate that's been in probate litigation for 9 years now. So every year I have to go out to all of the potential heirs and talk about the fact that you guys can either settle, come up with, whatever your resolution is going to be, or invest more money to pay the taxes, or lose it. So once the litigation gets real involved, 3-year escheatment or 3-year tax sale is a real possibility with a lot of businesses. If you're in a partnership, you're also going to want to think about the fact that if your partner is injured, do you really want to be partners with their spouse or their children? And do you want them to be partners with your spouse or your children? So there are some real important reasons why we want to be sure that we have a plan and not wait too long to put that into effect. Like I said, any one of us, any day, could be hit by the truck pulling out of the parking lot. So another thing that I like to bring up that I'm sure doesn't embarrass anybody today, but you may want to talk to your friends. What about your email, Facebook, Instagram, all of that kind of thing? Does anybody have access to that? And remember that it's out there forever. But whether or not it can be closed down, removed, deleted, you do have to take specific action in order to name somebody who will be able to take over your digital accounts and either close them, or if it's an account that's for your business, in order to update that and continue to use that. So your digital accounts do need to be included in your plan. Now, I'm going to start with wills. I know that's more of a personal kind of thing that you don't think of it with your business, but you're going to have personal assets and things that aren't necessarily in the name of the business. There may be a truck that you use in the business that you have in your personal name. As you go over a long period of time, everybody is not necessarily careful about making sure that everything is titled in the name you need it titled. So a will is the important piece that will protect you from everything that fell through the cracks. And if you need to fix something, any financial institution, any legal institution, the place that they're gonna start before they want to talk to somebody. It's a standard. They're going to ask for a copy of a probated will, order admitting the will to probate, and letters testamentary within the last 6 months that says this is the personal representative of the deceased person. So with everything else that you do, all the other planning that you do, don't neglect the will, because that's going to be the first thing that your heirs are going to need in order to fix any problem that comes up. And when you do that, be sure that you don't go to Office Depot and purchase a fill in the blank will. A will to be valid in Texas has to be all typed or all handwritten. It cannot be a fill in the blank form. Make sure that your witnesses are not your beneficiaries, particularly as people get older, people pass away. You don't want to have a will where the only living witness is the primary beneficiary, because that's not going to probate well. You need 2 witnesses and notary. There is a fill in the blank form propagated by the state of Texas that you can use. Just make sure that you use Adobe, something else, that you're not handwriting in anything but your signature. You're typing in everything except the signature. So just be very careful with that. It is kind of your belt and suspenders, but if there's a problem, and obviously as an attorney, people don't call me unless there's a problem, the will is going to be the thing that your heirs are going to rely on to get any issues solved for you. Remember, as if you have parents that you're trying to help, you want to take over some of their assets and you're talking to them about how to do that, remember the capacity to write a will is pretty low bar. You have to be of sound mind, understand the effect of writing a will, know what you own, what your property is, who the people you want to give it to are, and why. And you only have to have that capacity during the time you're discussing the will, during the time you're setting that up. So if somebody in your family already has a designation of some kind of dementia, Alzheimer's, or something of that sort, they have not necessarily lost the capacity to write a will and go forward with estate planning. You can be pretty far along in moderate and early stages, mid stages, before you would lose the capacity, the understanding of who your family are and what you own. But you will have to, when you're doing that, establish that you do have capacity. I think it's also important on picking the executor for your will, and the same issues with your powers of attorney, people to help you out. You have to pick someone responsible. You want to consider somebody who's probably in good financial standing themselves. You want to name somebody young enough to be likely to outlive you. Your older brother may not be the best choice. In this day and age, we don't have to worry about location. If the folks you're choosing to represent you don't live in Texas, They can name a Texas resident to accept mail for them, and they can serve. So you pick the best representative for you without being concerned about, this is the only family member I have who's located in the Houston area. You just need the best, most responsible, trustworthy person that you have. You want to the best of ability, avoid drama. There's going to be drama after you pass. It's going to happen, but don't set that up in the first place. Think about if somebody is disqualified. I have gotten executors named. Disqualified individual is somebody with a drug conviction, a felony, any kind of a fraud conviction. And like I said, I have gotten people named who had 40-year-old convictions, but it's going to make it more difficult. So if you have a responsible person, excuse me, who's not disqualified, go there. And last, somebody patient, emotionally grounded to the best of your ability, because it can get tough dealing with a lot of drama that they probably didn't cause. But once somebody passes and you can no longer resolve even small issues you have with them, they turn big. And be sure to talk to the person who is your agent, your executor in the will, your powers of attorney. Talk to them and let them know. Don't surprise people with responsibilities that they haven't had the chance to accept. Now, if you want to make charitable gifts, you need to make those arrangements during your lifetime. You can set up a charitable remainder trust. You can set up a gift annuity, but if you're making a charitable gift in your will or when you pass away, I spent almost a year getting $100,000 to St. Joseph's Hospital because they didn't know they were supposed to be getting that gift, and finding the appropriate people who could file the appropriate motions in court and turn that over, because there was all the other assets passed otherwise, and there was nobody to actually file on behalf of the charity to get the gift. So be sure to make those arrangements so that those gifts can take place during your lifetime and get that set up. Sorry. And you want to be sure to the best of your ability that you make those gifts from either appreciated property, IRAs, something of that sort, for tax planning purposes. You want to make sure that you're not paying the taxes on the property and then turning around and making the charitable gift so that you only get, a percentage of the deduction, where if you go ahead and just give them the property and never take that income, you're essentially getting yourself 100% tax deduction. So you want to be sure that you donate the appropriate items, the appropriate assets, and you make that directly before the income comes to you. The attestation is the verification of authenticity. So you need to make sure when you're doing your will that, I know it seems silly that you have to sign once I'm signing my will and once I'm signing the document that I'm asking these people to recognize that this really is my valid desires, but it's a requirement. And it does make the process a whole lot simpler after you're gone. But so we do have in Texas the durable power of attorney. And again, that allows the grounded and reasonable agent that you have picked the ability to transact business in your name. Up until 2017, they could refuse a power of attorney for any reason. And a lot of that was to protect the banks and that they didn't necessarily know whether a power of attorney was valid. So there's now the specific grounds. If there's a power of attorney, your agent can't start a new relationship on your behalf. They can only continue with the banks you already set up. They can, the law enforcement agency tells the bank, or there's a suspicious activity report, there's some reason for the bank to suspect in good faith that the durable power of attorney isn't valid. They can refuse it. And that is now the responsibility is now on the bank or the individual refusing the power of attorney, where before 2017, the responsibility was on you to prove that the power of attorney was valid. Then, of course, the medical power of attorney, these two kind of work together. The durable power of attorney allows somebody to pay your bills for you. Medical power of attorney allows them to talk with the doctors and make decisions for you. So for whatever reason, the HIPAA designation for the doctors to give them information regarding your condition is not part of the medical power of attorney. That's a separate document you have to make sure you sign. So be sure you do that. It does not allow medical, psychiatric medication, convulsive therapy. So there's another document. That's the Declaration for Mental Health Treatment. I haven't had a reason yet to have to do that. I think people who are at risk of this are probably not the folks who are doing advanced planning, but and the third thing with your medical that goes together is the directive to physicians, which tells folks this is where you tell them what you want for your medical treatment. Again, talk to the agents that you pick, whether it's for your will, for your powers of attorney, for whatever. Personally, what I have seen is I think it's best to give your agents the authority while you are competent so you can see how they use it. If you tell this person that you have made them your agent and they don't ask you any questions, then what they're going to do is whatever their opinion is, it's not going to be what you intended to have happen. So sit down with your agent and talk to them about whatever it is that you're giving them. Now, the medical power of attorney, that can be really, really hard to talk about. So you probably want to start that discussion on stuff that is less sensitive. You don't want to talk about, if it's about time to pull the plug, I don't want to be on life support for a long period of time. You're going to get to that. But you want to start with something less sensitive. I think one thing that you can talk about, we currently have the federal government looking at maybe decriminalizing marijuana. There are still a lot of people who really don't like the concept of marijuana, but it's a little easier to talk to them about, would you want medical marijuana for nausea? and kind of get into those kinds of things. If you got cancer and you were nauseous, would this be something you would want to have as a treatment, is a better place to start than, when you say you don't want to be in, a lot of machines for a long period of time. Is a long period of time 3 days? Is it 3 weeks? That's a tougher conversation to have. So start with less sensitive stuff. If the person gets offended and they start out with, well, why are you being so specific? Why are you being so specific? If they can't even talk to you about what it is that you want, they're not going to do well when the doctor is standing in the hallway talking to them. Or if we're talking about your financial durable power of attorney where they're making business decisions for you, that's the same thing. You want to start the conversation about if you had to take over the business, or if you're talking to your parents who are making you their agent, you have to have those conversations about what do you want done in these various circumstances, or else the agent it is not going to know what you want and can't possibly be expected to exercise their discretion in the way that you want it done. So you need to have those hard decisions, those hard conversations with people. And so think about some of the less sensitive things to talk to folks about first to make sure they're the right agent for you. The last thing is you can set up a designation of guardian. And that can be either the guardian of your person to help make medical decisions or your estate to run your business, which solves the problem of the refusal to accept a power of attorney. But the guardian has to act in your personal best interest, not exercising instructions you gave them. So the agent is supposed to do what you tell them to do. The guardian is supposed to do whatever is in your best interest. So that's the difference there. Now, you could also have a trust. A trustee has to do whatever it is the trust, whatever you've written in the trust instructs them to do. But trusts are really in Texas oversold because you've got to administer them, you've got to keep up with them. And that is one of the things that doesn't happen necessarily. I've got one that they set up some mineral rights trust to control mineral rights. And we're in the 3rd generation now. They've lost all the copies of the trust, so nobody has one. So they don't know how to name a new trustee. So the only option is to pay to go to court and get the trust amended so that a new trustee can be named and the trust can start serving its purpose again. But of course, this is, the 3rd generation, and they're in, well, we don't know if it's cost effective for us to make that expense to do that. So here's a trust that serves no purpose. Now, it used to be that the standard for a trust was that by the 3rd or 4th generation, the trust would just dissolve, which for a lot of trusts that people didn't keep up with paperwork, that's probably a good thing. Texas passed a law in 2021 that a trust can now last for 300 years. So that just adds to the problem of losing the paperwork. You know, there are families with enough money and enough resources that they hire trustees at a bank, and um, all of the records are maintained professionally, and they pay for the service of maintaining that. For a family kind of trust, grandma put the mineral rights and the timber rights for the land, out in, this rural county into a trust. You're not really all that commonly, your cousin doesn't keep the records when they move. It, gets destroyed in a flood. So, having a trust that may, by law last for 300 years, and if you don't have a copy to say how it ends or how you appoint new trustees, there's some costs in doing that. On the other hand, trust can be useful if you have property in more than one state, and you're gonna not want to have to do probate in every state where you own property. So you'll want to get a trust and put your property in that. Privacy. There are folks who have stalkers, then yeah, put it in a trust and don't have the fact that you own that property public knowledge. Obviously families with a whole lot of money that are afraid of their children, being kidnapped will use trusts for privacy issues. If you have pets and you want to be sure that you're caring for them after leave, you may set up a trust with assets designated for your pets. Ways to deal with children for previous marriages, special needs folks that you want to make sure they are still eligible for governmental benefits. And the thing about a trust is the transfer is fast. Now, probate in Texas is relatively fast. Probate in California and New York runs 3 and 4 years for a simple probate. And that's Susie Orman is in California. A lot of folks in New York, those are big media centers. So you get a lot of media push. You need trusts. And like I said, in California and New York, yeah, a trust that will transfer stuff within a couple of months is preferable to a probate that will take 3 years or more. Texas, our probates are really pretty simple. So for us, trusts are really oversold and don't necessarily serve all the purposes that we would like them to. We do special needs trusts are one exception to that. If you have a disabled family member, you need to fund that asset, that trust, from assets that you control. You cannot give the asset to the disabled person and then set up the trust with it. It has to be a gift, and then the remainder is distributed by the trust. If you give it to the person and then set up the trust from their funds, property that already belongs to them, then you're going to want to, there's going to be a ownership to Arc of Texas or some other organization that the trust will not transfer any remaining funds. So it's better for your control to make sure that any funds can be distributed to whoever you want them distributed to, by, much like the charitable, but, be sure that whatever asset you're giving away is going to the ultimate titled owner, not an intermediary. And there are revocable versus irrevocable trusts. So in order to get asset protection, a trust would have to be irrevocable. And because you don't own it anymore, you have now transferred that asset to a non-human person. So, but you can't make any changes to the trust. You can't move stuff out once it's in it. It's no longer yours to control or own in any way. The revocable, it's just a new name. It's like a DBA kind of thing where you get the privacy that the name is not out there, but there's no tax effect. There's no other effect until, as the person who set the trust up or the grantor, that's the only time that then it becomes an irrevocable trust and is protected from creditors, cannot make additional changes. That's the one that folks frequently do with mixed marriages, make sure that the assets that I want to transfer to my children are transferred to my children, and you can't make changes to our plan once I've passed. So that's one of the primary uses for a revocable trust. Now, alternatives to probate or the whole will process, and that is you can do a transfer on death deed for real estate. So for real estate assets, you name whoever you want to take over your property. You file the transfer on death deed in the county records, and when you pass, it just happens. So there's no having to go to court, having a will. Your real estate will just pass, whether it's your home, your resident, an apartment complex, whatever that real estate may be. For vehicles, there is a DMV form that says if there's no will controlling the car, you just fill out an affidavit to do that. Assets with financial institutions, you can go ahead and set up beneficiaries. You probably want to do that. So it's an immediate transfer, again, like the real estate transfer on death deeds. If the estate that's left after the other financial institution beneficiaries transfer on death, if what's left is still relatively small amount that needs to be transferred, you may be able to do a small estate affidavit for some things that you forgot to deal with any other way. And if there is no will and a small estate affidavit there's too much assets for that, an affidavit of heirship may be your alternative. Now, for the business itself, how that's going to be distributed at your death is going to be controlled by the articles of incorporation or bylaws that you write in your business. And I'm always big on telling people that you need to plan the divorce while you still like each other. And by that, I mean, when you set up the business and you're filing your articles of incorporation with the state to set up your LLC, when you're initiating your partnership and you do your partnership agreement, that's the time that you talk about what happens when one of you passes. That's the time that you deal with the questions of, do I want to be partners with your spouse or your child if you're hit by a truck? And those are the things that you're gonna put in your bylaws that say, if something happens to one of the members of our LLC, then you have the right to buy out the other one, that you don't have to continue the business with the spouse. Or maybe the spouse gets a non-voting share and only gets an income stream. So whatever it is that you want to have happen with that, that's what you put in your articles of incorporation or bylaws. It doesn't have to be in the articles of incorporation. That's the document that you file with the state. But if you put it in your bylaws that you keep for your business, then obviously it's a little more private. But that's still, when you pass, or, you know, when something comes up with your business, that's where you're going to go look for what are the instructions on how to either close down the business or distribute the business, or whatever it is that you're going to try to do at, I said, incapacity. You'll have in there what's the criteria for deciding that someone has sufficient dementia that they need to be removed from the business. Whatever those things are, that's where you spell it out, and that's where you have that discussion when you're first setting up the business. That doesn't mean that if you have an existing business and you haven't done that, that you can't go out and amend your existing bylaws to include those kinds of issues. But listen, I always recommend, when folks are starting a business, to have that thought process right off the start, because, you know, a lot of times after you've butted heads for, you know, 3 or 4 years, you're less open to compromise, maybe, is what I want to say. So that's the thing that you're going to want to pull your bylaws and make sure that those do whatever it is you currently want them to do. Your final arrangements, you can do prepaid funerals if you go through some kind of a national affiliation, not necessarily a national chain, but at least a national affiliation. Or if the funeral home has an insurance policy, they frequently have insurance that will make it transferable. So say, you know, you prepay for your funeral here, and for some reason you move to New Mexico, and that's where, you know, when you pass, you want to be buried. If you've done the prepaid with an insurance clause, then a funeral home in New Mexico would be able to do that. Again, make sure your agent knows the terms of anything that you have pre-planned. You can there's just straight up burial insurance that gives a certain dollar amount for your funeral. And there is another option of a designated agent for disposition of remains if you don't have family members, or if the close next of kin might have some disagreements about how they want it to be done. You can designate an agent who will be able to take care of it right away. So you don't have to go through probate of at least 60 days waiting. There's, some pretty famous people who didn't get buried for quite some time while the family fought about it. You don't want that to have to happen to you. Okay. But dementia is a concern. And the population of people with dementia in this country, affected by dementia, is, well, not in this country, but worldwide, is the population of the country of Turkey. So when you're making your plans, you need to be sure that you're planning for the contingency of somebody is going to get dementia. And it is not normal aging. Women are more likely to get it than men. African Americans are more likely to get it than Caucasians. There are a whole lot of things we just don't know about it, but it's common, and we do need to plan for it. That's both for us and for our parents or others, how we're going to provide care for them. It's estimated that currently 16 billion hours of care a year is being provided by family members, or $272 billion of GDP is just not there because it's unpaid family assistance. So as part of your plan, it is tax deductible. It is a business expense. You probably want to look at long-term care insurance. So on average, women are requiring care for about 7 years, men about 2, and you want to apply for it early. Typically, if you wait until you're 75, no insurance company is going to think that your premiums are going to be sufficient to make it cost effective for them to insure you. If you already have some diagnosed condition, you're probably not going to get it. So look into it at a younger age, because household care is expensive. And it kicks in at the time what you can't do 2 of the 6 defined activities of daily living. So be sure to consider that. Now, we are currently just passed the laws changing, extending the estate tax. So when you're looking at assets, most of us do not have to be concerned about the estate tax. It is $15 million per person. And when I say portable, that is each spouse can make gifts up to 15 million, which means as a married couple, you can transfer $30 million without paying an estate tax. Texas does not have an estate tax. If you have property in other states, you'll have to look into whether that state has an estate transfer tax. Some states, a lot of states actually do whatever the federal government is. Our estate tax is 10%, 15% of the federal tax. So with a basically $30 million estate tax on the federal level, most states aren't having estate taxes now, which explains a lot of why we're increasing other taxes for the states to fund themselves. You do want to consider lifetime transfers versus testamentary transfers and charitable gifts. So if you transfer something during your lifetime, one of you will pay the appreciation of the capital gains tax on it. So if it's a testamentary transfer, there's a step up in basis to most assets without any capital gains tax. So you want to transfer you can leave your stock in your business, you can leave the real estate in the will, and you'll get the you'll get the step up in basis for your heirs to not be taxed on the capital gain over the course of your lifetime. Same thing with charitable gift. You can make a loan to the business or the charity. Yeah, make a loan to the charity, and then in your will, you can forgive the loan, and that will be 100% tax deductible, as opposed to just the percentage of tax that would otherwise, the percentage just deduction you would otherwise get. Sorry about that. So I did have a couple of questions that I had been asked, and I wasn't real sure that I understood. I had been asked if an LLC would protect a business after the owner dies. And I'm not entirely sure what that person meant by protect. But what happens to the LLC when you pass away is absolutely controlled by those bylaws. How it's going to be, is it just passed by your will? Is it passed to your heirs at law? However you define that in the bylaws of how the company is going to handle the trust. If you don't have that, then it is going to be by the terms of your will or by the inheritance. So it's also going to depend on really what is your LLC. So what is it that you're transferring? I have a PLLC for my law firm, but I can't leave my license to somebody else. Essentially, I'm limited on what I can do with anything by my company. So if you have a company that is a trucking company and you have, a fleet of trucks, that's different. And the trucks are going to be titled in the name of the business, and your membership in that LLC is going to be your asset. If you haven't titled the trucks in the name of the business and they're in your name, then again, that's going to be based on your will or whatever else you have in place that's going to transfer those vehicles. So you need to not think of the LLC as the transfer mechanism, but consider that that is whatever that LLC may be, is the asset that you're going to transfer with one of these other mechanisms. And all right. The question is, let's see, the irrevocable power of attorney for an LLC owner. All right. Yeah. I don't think I would ever do an irrevocable power of attorney, just because essentially what you've done, because it's irrevocable, you have transferred your property to somebody else. So I would have to look at that irrevocable power of attorney, and if you'll send me or go through and give me your name, I can look that up for you. But there are so many other ways to transfer a business during your lifetime that would give you the ability, if you change your mind. Again, like you could change your bylaws, you could change your will, you could change any number of other places. But I'm just kind of opposed to something that's irrevocable before you pass, just in case you change your mind. Sorry about that. So, did we have any other questions? Let's see, what was.
I don't see any other ones in the chat, but I actually had a couple of my own questions, so
Okay.
I'll let you finish before because I was kind of writing notes as you were going, so I'll wait
Oh,
till
okay.
you're.
Well, I'm actually kind of at the end of my plans. I do have some, I list the resources here. Some of the easiest places for personal estate planning, AARP is good. Obviously, the Alzheimer's Association is always great for dementia resources. But I will say, don't shortchange the Texas Area Agency on Aging. They have a lot of programs that are really good, really helpful, not just for businesses, but the Ombudsman program is great for nursing homes, that kind of thing, where there's an assigned person at the nursing home to help your parents, with whatever questions you have. So they do work with people for various benefits, Medicare, Medicaid, the Section 8, anything of that sort. So yeah, don't. And I assume that a lot of business folks are in the 50 or over range. So that's why I say, don't shortchange them. They're very helpful. So yeah. And what were your questions? I'm sorry.
One of the questions that I did have when you were talking about revocable versus irrevocable trust, how does if someone created one, would they know if it's revocable or irrevocable, or how would they know?
It's going to be in the wording of the trust that you wrote. And so if there's a section that says most commonly, this becomes irrevocable on my death. If there's a section on it's going to say I have the ability to make changes to this at any time during my lifetime. That's going to be the revocable trust.
And in most LLC formations, is there a space in there where they kind of create this succession plan or figure out what happens to it in the event, if it's just the one person, it's not like a partnership or anything like that, what happens to the business in the event of their passing, or is that something that they have to be intentional about adding?
You have to be intentional about adding that. The articles of incorporation form for that you file with the state of Texas just asks you if you intend it to be in perpetuity or if you intend it to end on, a specific date in the future, which of course most people pick the I want it to last forever, so that they don't have to deal with that. So then I said, you can put various things in that article of incorporation, but most people don't. They usually just leave it kind of at the bare bones form that the state requires you to do. And some people don't do the bylaws at all then after that. But that's where you're going to put in, and like I said, the bylaws you just keep with your corporate books, your minutes of your meetings, all of that kind of thing. And that's where you have to do that. And honestly, I've looked at some of these online forms, and I don't see that. And I think it's an important thing for people to think through. I think a lot of people who set up businesses, as much as in order to start your own business, you have to be an optimist. I mean, you have to have a certain amount of optimism that this business is going to, take off and it's going to do well, or you wouldn't put that energy into it. But then they don't make the next step about, and then what happens with my business, when it grows to, more employees than just me. And so, again, you can update those bylaws anytime, you can create those bylaws anytime, but that's something that you pretty much have to do on your own.
Wow. Yeah, I bet that's something that a lot of people really just don't think about. If it's not on the form for them to fill out, they're probably not even thinking about it at all.
No,
Um,
that's sad. And that is, you'll find, most attorneys will laugh about some of these, online forms, and, we'll joke about that's fixing those is one of our big income streams, because they don't include a lot of things that would trigger people to know you really have to think about this.
mhm. Okay, so in the event that it is a sole proprietor or, just a one person kind of LLC, when in the event of their passing, what's the step for the family members? What do they have to do then to start that process? Are they supposed to go out and talk to an attorney to get them to transfer assets or move them around, or do they just do this on their own? Like, what happens? What's next?
Well, yeah. Hopefully, the person who set the business up has talked to an heir, somebody, and if there are bylaws somewhere that do that. And that's hopefully that is. I always recommend to folks that they put their important papers, if nothing else, in a Ziploc bag in the freezer, because somebody's going to clean out your freezer. The things that folks are going to have, know, whatever, to take care of things after you're gone, if you don't have a fireproof safe, if whatever. So hopefully you've got those documents somewhere. And then it's going to depend on what you have. The assets are in the name of the LLC, then you may have to, probate the will so that the LLC membership goes to somebody. The Bylaws may say in it that, this is going to go to this person specifically. So it's going to depend on what plan somebody has put in place for that business to move. And if that person doesn't have a plan in place, then the only thing you're going to be able to rely on is going to be the will and the vague comments that say, all of my assets will go to my wife, or all of my assets will be split equally between my children. Then you'll have to get yourself named as executor, or get the letters testamentary that have to be renewed every 6 months. And then you're going to take that letter testamentary and start selling the trucks, or whatever it is you want to do, or transfer the business into your own name if you want to continue the business. But if there's no other plan in place, then it's going to be their will in the residual clause is going to cover their ownership of that LLC.
Okay. Interesting. So if you guys have any other questions, please feel free to jump in and raise your hand, because I'm, my mind is running here. So I'm thinking of other stuff and I keep asking and keep asking. So if you guys have any questions, and I'm still also monitoring our YouTube comment section here too, just to make sure, but I'm not trying to monopolize or Miss Melissa's time here. So if you guys have questions, please feel free to chime in. So the other question that I have is about the business expenses as well. Are those things handled just like if it was a regular will, that the LLC or whoever's now in charge of the LLC or whatever, are they to pay off the creditors? And what happens when there's those business expenses that still need to be paid out? Or what happens, in that
Yes,
regard?
all those expenses still need to be paid, because the LLC is the asset, and you have to get down to what the net value of that asset is. So you pay off the creditors of the LLC, and what you have left is the value of the business that you're passing on to somebody else that this other person is taking over. You're supposed to, and I say this, if you're closing down the business, then you have to go through the process with the state of Texas to close the LLC, the same way you had to go through the state of Texas to open the LLC. Honestly, I have not found the state to really do anything, because, we've had people pass away that we find they had LLCs that really, weren't making money, that kind of thing. We can't find the tax returns. We can't find the corporate ID and we haven't been able to close it down. Now, supposedly there's a $50 a year fine for every year you don't, prove that you've filed all the taxes and get the business officially closed. You're supposed to do that. Like I said, a lot of times if the records aren't good, finding all of the information you need to close that is really hard. And so I have not found the state to take any action against a family member for not getting that done.
In that regards, what does a family member do if they never even knew about it in the first place? Like, what do you?
I think that's the position the state takes, that, it was the deceased's issue, and, it's like any other obligation of the deceased that doesn't pass to their heirs. If there's no asset to be transferred, if there's no money or financial, eh, then, and if the people don't find out about it, you don't have an obligation to even investigate the finances of a decedent until after you're named as an executor. So, yeah, there's no liability to a family member who doesn't know about it.
Hmm.
I don't think
Okay.
there's any liability. There's no obligation to search for it.
Okay. Interesting. When you mentioned, like if someone has like a fleet of trucks or something like that, are they, or are the heirs required to, if the trucks aren't paid off or whatever, do they just turn them back over? Are they required to sell them to pay off debts? Or, how does that work? If you've got equipment or something in an office, and
Mhm.
you've got printers and whatever, just inventory, you've got stock, you've got merchandise, you've got all of this stuff. Is this stuff to be sold to pay off the business expenses that are still left, or does it just sit?
Well, I mean, if you're taking over the business, then you're taking over all the assets. And it's your responsibility. If what you're choosing to do is to, you've taken over a nursery and you're, selling all of the plants in order to pay off the debt, then hopefully at the end there's a profit you're going to receive. If, you take it over and there are losses, there's more debt than there is asset, what I would do would be see if the creditors force your business into bankruptcy. I mean, that's an option. And, make them take it back, whatever trucks or, whatever that may be, and get a bankruptcy court to auction it off. So there are some ways to do that if it's not going to be profitable when you're done. But obviously, if all of the assets are in, it's a DBA, it's, whatever, all of the assets are in the name of the individual, then whatever you get in your inheritance from them, you deal with. If the assets are in the name of the business, then yes, first they have to go to paying off that debt. But if the will or whatever else leaves you a business, and again, it's not profitable, you can refuse to accept the bequest. So, there are some things that you can do if the business is not profitable. And it's, listen, when you talk about, just leave it and let it go rather than paying off the debt, then yeah, there are ways you could do that. You could deny the bequest and, not be bothered with it, at which point, if a creditor wanted to, they could go to probate court, file, whatever, and take over the assets themselves. There would be ways creditors could do that. But
What happens if you've got a business where you're offering a service and something happens to the person that's supposed to be providing the service as opposed to a product? At least, with a trucking company, somebody can get their trucks back. But if you were already paid for a service and now unfortunately the person passes or something happens to them, and then now they can no longer provide that service, what happens? How does the client then, what happens to the client then in that regards? And I'm asking this question because I had a friend of mine whose attorney actually had a fire all records, everything was completely destroyed. And then the attorney immediately got sick right after the fire and could no longer then perform the service. I mean, and couldn't do anything, but the attorney had already been paid. So client now no longer gets the service. So what happens?
Well, yeah, that's difficult. You know, as an attorney, we're supposed to, if we're sole practitioners like me, we're supposed to have somebody else that we have a relationship with that will take over for us. And I've done that for several attorneys, but I've had exactly the problem. I have a case now, which is exactly the problem that your friend has. Um, the attorney went on mission and doesn't appear to have ever come back. And never made arrangements for his cases. Unfortunately, that's a civil fraud case, of I paid this person, they didn't provide the service, but is it, is it worth suing the person to get your money back? Do they have it? Do they, but that's your option there. If as a client, somebody has, just gone out of business, it's the same as the person who comes to your door after a hurricane and says that they're going to work on your roof, and you give them 50% down so they can go get the things they need to work on your roof, and they never come back. Sorry.
As a business owner, is there something that can be put in place prior to, not just saying necessarily attorneys, but if there is a service or something to be performed that can protect them?
That can protect your clients. Yeah, you can get business insurance on that. Yeah. Now, is the client going to know that you have that insurance and know that they can apply against it? Is that in your, agreement with them? Is that in your initial documents when they hire you? But yeah, you can make an arrangement for that, to have an insurance policy or something along those lines to do that. But then you have to do the affirmative informing them that exists for them to, I'm sorry, to file against. Now, there are certain businesses, construction is one, where the state of Texas, it's been enough of a problem that the state of Texas requires people in that industry to have a bond.
Mm-hmm.
And if people know about that, then they can go file against that bond for people in that industry. But it hasn't been a big enough problem for Texas legislatures to have required every business to do that, or to require every business to have insurance for it.
Okay. Is there a tax filing that has to be done similar to for the business, the same as an individual? Example, or what I meant specifically. So when someone passes, you have to open up a bank account in the name of the estate to pay off all the creditors, file the final tax return. Is there something final that needs to be done like that for a business owner as well, or for the heirs of the business owner? Do they have to do that kind of thing?
Not specifically. Now, if you had the business and your it was a single member LLC, and you filed that as a Schedule C on your personal 1040, then in your final tax return, you're still going to have that Schedule C in your 1040, and that's going to close it out in that final return there. If the business is filing its own tax returns under its own tax ID number, then it's going to file its taxes for that year. And if you close it down, then, you get the notices from all of the agencies that, yes, all of the taxes for this business are paid and you can officially close it. Or if you just never file taxes again under that EIN number, then it again depends on what taxes you've been paying while the company existed. But in order to close it, you would have to get the letters, the certification from the comptroller that all of the sales taxes required were paid, all of the franchise taxes required were paid, in order to close it.
Okay, and then my last question here. So if you wanted to then leave your business and somebody was to is intended for somebody to take over your business, what do those heirs do? So if it's a small plumbing company or something like that and it's family owned, kids have been working there, you're now supposed to take over the business for dear old dad who's passed away. What do they now have to do to make it all theirs or put it in their name?
And again, it depends on how dad had it set up. If it was a single member LLC for dad, and it's not somewhere in the bylaws on what you want to do, then you can go out and file an amendment to the articles of incorporation and list the new owners for the business and file that with the state of Texas and take it over. If it's had its own EIN, you just keep filing the next year's taxes as if nothing had changed. But you do have to change the owners listed with the state of Texas. And that's with the Business Records Office. There's an option for changes to the articles of incorporation, and one of the boxes are, we're making this change according to the processes that are spelled out in our articles of incorporation and bylaws.
Is that with the Secretary of State's office or is that?
Yeah,
like
that's with the Secretary of State's office. Yeah. Where you filed your articles of incorporation is where you're going to file your amendment to the, or where the decedent filed the articles of incorporation is where the heir is going to file their amendments to that article, those articles. And then, like I said, if it had its own EIN, you just keep filing your taxes under that EIN. If it was a Schedule C on your parents' tax return, then you now have to start that Schedule C on your return. And I haven't had that exact problem, but there is a box you have to tell the IRS, is that the first year of the business? And I don't think you would have to do that because it's the first year you've done it, but not the first year of the business. So I don't think you have to do that. I haven't had that exact problem, but I'm trying.
Okay, let me make sure I'm going through my list here. Okay, I think those are all the questions that well, that's all the questions that I had. I don't know if anybody else has any other questions. Thank you very much, Erica. Thank you for the time as well. Thank you. You're very welcome. Are there any other questions from any other participants that are here? Everybody's been pretty quiet here today. We usually get a little bit more interaction and engagement from folks, but I don't know if you got everything that you needed, or if there are any other specific questions that I was just, again, going off the top of my brain here as I was kind of hearing some things. So I don't want anybody to walk away not getting any information that they didn't.
Well, I think you have my contact number, so I guess I can, if folks have questions, I can certainly, send them and I'll try to answer.
Okay, let me go ahead and give your contact information as well, so that way I can have it in the chat for the folks when they see it, and I'm adding it in here as I go, and then for the people that are watching on social media that can't see the chat. So if you could give it aloud.
Now let's do this.
Again, as Melissa said, if there are any other questions, please feel free to reach out to her directly, or if there's something else that comes up. Okay, she has included her email address here in the chat. Melissa Botting, I'm sorry. Pronounce that, please. I don't, because I don't want to call you the wrong. Is it Botting?
Botting, yeah.
Botting, okay. Melissa Botting, email address is Botting, BOTTING, the number 11 at gmail.com. If you have any questions to send to her directly. So it is included in the chat. Again, we did record this session, so we will be sending out a link for folks to go back and watch it in case there's something that they've missed, or if you want to share it with family members or other folks that may have some questions or could find this information to be useful as well. The resources that she did talk about throughout the presentation, I will be including those in the email as well, along with a link for our YouTube channel. If you guys are interested in following Amos Houston on YouTube, we are there, where you can see a copy of the recordings of previous presentations that we've done as well. Those are there, and then that link will also be included. So I really do appreciate your time. Thank you very much. You did a wonderful job. Really appreciate it. Thank you, Jesse, for making the arrangements. Again, we've had some folks, that have come on to our regular monthly wills and estate planning session that had questions about their family business and wanted to know what happened. Andrea Cobb wants to, if Miss Cobb, if you could just shoot her an email, she'll send you the phone number and her other contact information as well. But it'll be included also on the email that I sent out to you all. And I hope, again, I hope that your questions that you may have had or the information that you would hope to receive was included here today. If you could just take a quick moment following the presentation, you'll see the link for our survey that pops up. Take a minute to just, let us know how you're doing. If there's other information or other topics that you guys would like to have more information about, then please let us know. Provide us with your feedback so that we'll know as we're planning future presentations what it is that we need to provide for you all. So we do definitely want to hear from you and value your opinion and your input as far as the presentations that we provide for you all too. So Ms. Melissa, thank you again very much. Really appreciate it. Ms. Jessie, thank you very much for joining us, and for all of our participants. Thank you all for tuning in this afternoon. Tomorrow, no, not tomorrow. What's today? Today's Tuesday. Oh God, already we're on the 14th of August. On Thursday, we will have our inherited property and clearing title for inherited property presentation and other probate concerns, and that's going to be on Thursday at 1 p.m. So if you all need more information about that, we definitely invite you to join us. Next week, we have our evictions and tenant rights, as well as maintaining and adding value to your home for those two presentations we've got scheduled for next week. And they are also listed on the website for you all to go back and to register. I will also be sending out the calendar of the August schedule so that you can see everything else that's scheduled for the remainder of the month as well. So that being said, thank y'all very much. Y'all have a wonderful remainder of your afternoon. Take care of yourselves and stay safe, and we'll see y'all next time. All right, thank you.